All right, we'll go ahead and get started. I have our recording started for today. For the record, today is Tuesday, March 19th, 2024, at approximately 9:02 a.m. here in the Cordell Hull building at the Volunteer Conference Center. This hearing is being conducted both in person here at the Cordell Hull building as well as telephonically using Microsoft Teams and is currently being recorded. If you have technical difficulties or for some reason get disconnected and are not able to rejoin the hearing, please contact Kawana Barbie at 615-747-5386. We only have a couple parties on today, or a couple representatives, and so we know who they are, so if they get disconnected, we'll also reach out to them as well. It's pretty easy to do. We are present before the Tennessee Assessment Appeals Commission, who've been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related matters. My name is Robin Pope. I currently serve as the Executive Secretary to the State Board of Equalization and am designated to sit with the Assessment Appeals Commission as a hearing officer. As hearing officer, I will preside at this hearing, rule on the questions of the admissibility of evidence, advise the commission members as to the law of the case, and ensure the proceedings are carried out in accordance with law. Otherwise, generally speaking, my role is mostly administrative. I'm here to make sure that the proceedings are carried on and we are scheduled, that they can move forward, that we're going to stay on schedule. But I most importantly, do not participate in the decision making on the outcome of the appeals. So that is going to be our commission members today, the folks to my left, for everyone in the room. You will be our decision makers. I do not participate in the deliberations. I do not get a vote in the end of outcome of your decision. Mine is mostly just procedural and sort of making sure that we're moving along. I will now make some introductions before explaining the rest of the procedure for today. During deliberations across from me, Mr. Miles Crandell will serve as counsel to the commission. He will assist the commission with questions of law during deliberations, as well as offer guidance regarding the legal sufficiency of their conclusions. I'll now ask our panel members to introduce themselves. I think probably from, our right to left, your right to left, my left to right, starting with, and I just totally blanked on your name. Don Osborne, there we go.
Don Osborne.
Mr. Rusky, make sure we heard you. You might have been able, I just didn't hear the echo.
My name is Phil Russ.
Yeah, it came through.
Okay.
And Mr. Russ, as our chair of the commission, you'll be our presiding member today as well. As presiding member, you will concur in the final written decision. Let me make sure. And you're familiar with that process. And so for both of our parties today, essentially within 90 days of today's hearing, you'll receive a decision, a written version of the decision that they'll make today, and that will be signed off by Mr. Russ. All of the, well, I'll save my next comment. I'll do some preliminary work. So I usually don't skip around like this, but I'm gonna skip around a little bit. We had several appeals on the docket for today. All of our appeals are represented by Mr. Daniel Knox, who I can see on our gallery, and all but one are represented from the county side by Mr. Lee, who is here in the room before you as well. Both prior to today and yesterday and last evening, we got several withdrawals, and I just kind of want to make sure we get all of these. I'm going to go through our docket of cases and go through the ones that I have as withdrawn. And then Mr. Knox, if I get anything incorrect or we have any other additional updates, just let me know. I just want to make sure we get this on the record. Let me make sure I make some notes for this as well.
Mr. Before we go there, can I just circle back and get the panel members? All I heard was Don Russ and then Don Osborne and then Phil Russ. Now I'm assuming Mr. Russ is in the middle on the table there. But I didn't.
No, yeah, sure.
I am Tim Profit in the middle.
I'm sorry, Jim Profit.
Tim, T-I-M.
Okay.
You might need to get real intimate with that microphone. I know mine's pretty hot, but
yeah, can you hear that?
That's much better, Mr. Prop.
I can hear the reverb, but yes, Proffitt.
Thank you, sir. And then you're in the middle, and on the far right, the gentleman with the bottle of water is Don Osborne.
Don Osborne.
Okay, okay.
OSBONE. Don Osborne is on your left.
Just raise your hand, Mr. Osborne. And then Mr.
Okay, very
Prophet,
good.
raise your hand.
My name is Phil Russ. I'm the one with the water bottle.
Okay, and that's RUSS, correct?
Yes.
Okay, thank you, gentlemen. I appreciate you clarifying that for me.
In the list of cases I have, I'm going off of the alphabetical list from the admin records I shared previously.
Okay.
Was originally Beaver Hollow versus Washington County, case number 130049. Brownsville Elderly Housing versus Haywood, SBW number 112379. Chloe Lane versus Hamblin for tax year 2019, case number 125459. Jeffrey Meadows versus Henderson. I don't have that case number right in front of me, but I'll get it in just a moment. Followed by Marshall Gardens versus Gibson. We then had Olympia Construction versus Hardin County for tax year 2016. Olympia Construction versus Hardin for tax years 2017 through 2018. And then we had Olympia Construction versus Hardin for tax year 2019. We then had Stone Ridge Estates as one case for tax years 2017 through 2020. We then had the Villas of Savannah versus Hardin for tax years 2016. And then we had the Villas of Savannah for tax years 2017, through 2018. And then Mr. Knox, I just wanted to confirm because we got a few different withdrawals last night. So I have with me withdrawal for, let me make sure I get this. It's my understanding that the Beaver Hollow, the limited partnership versus Washington County, that being case number 130049 is withdrawn. I then have Brownsville Elderly Housing, limited partnership versus Haywood County Assessor's Office, case number 112379 as withdrawn. And then also have that you had withdrawn Chloe Lane versus Hamblin, case number 125459. That was our one case with Mr. Ely as the county assessor of property.
Yes.
And then we
And I copied him in on the withdrawal, and I know Mr. Lee is not representing that county or that property, so I took the liberty to copy in the assessor.
Okay, perfect. Thank you. Yes, I saw that. I just want to make sure. Okay, so we got.
Yes, sir.
No. And then I have that Jeffrey Meadows is still on the dock. Jeffrey Meadow versus Henderson County is still on the docket for today.
Correct.
Okay. Just taking notes so I can have this down. And then the next one I had was I have that Marshall Gardens versus Gibson County for tax years 2017 and 2018 is still on the docket today, correct?
Correct.
And then I have, let me see here. I have one withdrawal for Olympia Construction, and that being for several, I think for all 4 tax years. Is that correct? 2016 through 2019?
That's correct. You need me to give you the appeal numbers? Confirm.
Oh, I have them here. I have them here. Let me so I got that. And then I have a withdrawal entitled Stone Ridge Estates Limited Partnership for one. I only have one case number on here. I just want to confirm if it's just for the 1 year and kind of go through this real quick. Just give me a moment to pull up all right, the initial decision in order that I have as dated, I believe, what was that date on there? April 12th, 2021, covered tax years 2017 through 2020.
Correct.
And on this withdrawal. Mm-hmm.
But they were all appealed separately, so I went to.
Okay. Sorry, so I only have the The case number 131495 is withdrawn, and that would be tax year 2020, but that will otherwise still have tax years 2017, 2018, and 2019 on the docket for day. Is that still correct?
I think we've lost his audio.
Mr. Knox, I'm sorry.
I'm sorry. Yes, that is
Okay,
correct.
okay. So that was 2017. I'm just typing this in real quick. But that 2020 is withdrawn. Okay. And then last, in alphabetical order, we have the Villas of Savannah. I've got 2 withdrawals, and let me make sure I get this right as well. Go back to the. All right, I've got a withdrawal for the 2016 tax year, I believe. That's case number 107638. And then have a withdrawal for case number 112378. Let me pull this up and see. Which is the 2017 year, I believe. And then I've got a withdrawal for case number 125458. I'm trying to see which one. Is this 1, 2? Okay, and so I have the case number 125458 being tax year 2019 as withdrawn.
Correct.
And then I have, okay, as well as, let's see, what was this? 107638. As well as tax year 2016 and 2017.
And that case should
And
number
so-
should be 112378, correct?
Yes.
Okay. So the only one that for Olympia or for Villas of Savannah that survives or that's still active is 119494.
Okay, perfect. Sorry, I'm just making one more. Okay. Commercial Gardens in its entirety. Jeffrey Meadows in its entirety. Stone Ridge Estates for tax year 2017 through 2019. All of Olympia construction is withdrawn, and then everything except for tax year 2018 for the villas of Savannah. Okay, so we'll tax years 2017 through 2019 are still going forward. The 2020 was withdrawn only.
For which property?
The Stone Ridge Estates.
Oh, yes, correct. That would be 113495 is the case number.
Yes. Okay. Okay. We'll go through that too when we get into the individual cases. I just wanted to get that right off the docket because it makes a couple differences for the rest of the introduction this morning. So with those withdrawals received and confirmed this morning, we will process that. And I just saying it out loud, Mr. Knox, I understand that you confirmed that those withdrawals were all correct as I read out. The proceedings being recorded, so if we need to refer back, we can. But we will get those processed as well, and I have those as recorded and filed before and during today's hearing. So therefore, we don't need to go through those today. We'll process those withdrawals. Okay. All the remaining appeals to be heard today are to be conducted based on the record available before the administrative law judge during the prior hearing. Pursuant to Tennessee Code Annotated 67-5-1506, as effective through June, was that 2022, I believe it was, or 2023. The Assessment Appeals Commission has a couple options today. And so I'm going to go through these slowly too, just to make sure we're all on the same page. Kind of reiterate what they mean. The commission, your job today is you can do a couple different things. You can affirm the decision of the hearing examiner. That's the administrative law judge decision. And essentially, rubber stamp it, say they got it correct. You can remand the case for further proceedings. So if you think the judge didn't go far enough, or the judge maybe their decision wasn't incorrect, but they need to do a little more work, you can remand it to the administrative judge. You can also reverse the decision if you found the judge got the decision wrong, and that incorrect decision resulted in the rights of the petitioner being prejudiced. For something about the decision, the findings, the inferences, the conclusion, or the somewhere in the decision is otherwise either one, in violation of constitutional or statutory provisions. So essentially, did the law follow and apply the law correctly? In this format with I usually say it's the law of appraisal. We all kind of know the basic, between a willing seller and a willing buyer. That's the law we're applying, which is largely the law of appraisal. So did the judge get the law of appraisal correct in this case? Was it otherwise made upon unlawful procedure? Did the judge not follow some proper procedure, or was there some abuse of procedure? 3, was the decision arbitrary and capricious or characterized by an abuse of discretion, clearly unwarranted exercise of discretion? Some of them more self-explanatory, but essentially, was that decision arbitrary? Did it just totally not follow the evidence or something like that? 4, and this is more accurately, unsupported by evidence that is both substantial and material in light of the entire record. And so part B is in determining the substantiality of the evidence. You as the commission can take into account whatever in the record fairly detracts from its weight on a question of fact, but you can't substitute your judgment for that of the administrative judge on questions of fact. So essentially, you're not required to ignore that there may be, the record may support 2 different conclusions. However, your job is not to reweigh that evidence. Your job is to accept that the judge made a finding of fact. You are entitled to look at the record to make sure that that finding was supported by evidence. Did the judge make a finding that was totally unsupported? And you can look at the entire record to see that. And you can look at the record, not required to ignore inconsistencies or that, 2 different opinions were generated and things like that. But if the judge made a finding of fact, you can look to make sure it was supported, but you're not allowed to, supplement your decision for that of the judge on factual questions. And so I usually have a colorful example here about, essentially, additionally too, I always say that if you find a fact is so essential to the disposition of a case, but the judge didn't make a finding one way or another, you can remand to the judge to specifically make that finding. For example, if you believe it is essential to have the exact square footage to determine a proper valuation, but it is not apparent on the four corners of that page that the judge actually made that finding of fact on the exact square footage, you should remand the case back with instructions for the judge to find that square footage, and to the extent it makes a difference in the valuation, the judge should adopt that valuation change. This would be correct even if you yourself could see in the record that there are multiple, or there is a clear square footage to you in the record, and it's not your job to make that finding of fact, it's your job to point that out to the judge if they failed to do so. This means that today, based upon now that we have those cases as withdrawn, no new or additional facts, testimony, documents, or other evidence may be presented to the commission unless it is related to an irregularity procedure that is not shown in the record. I don't have anyone as claiming there's an irregularity here today. A copy of the record was previously presented to our commission members via Microsoft OneDrive, as well as it was uploaded to our public portal, along with any written argument submitted by the parties in each case before the commission. If we need to have a physical copy, we can, but otherwise, if we need to reference any portions of the record, I can pull it up on my screen. And if we do that, feel free to move around the room and get a closer look if that's what you would like to do. We will generally proceed with one case at a time, taking breaks only as necessary. For no particular order, I probably will just go alphabetically today. Like I said previously, our only representatives are going to be Mr. Knox and Mr. Lee. Let's see. The proceedings are otherwise informal. We will generally start with the appellant, which is Mr. Knox in all these cases, and then we'll hear from Mr. Lee, and Mr. Knox will have a brief opportunity to respond. You as the commission are free to ask questions at any time. Given the half virtual nature, though, I will usually pause to make sure if you have any questions that we get those heard. Prior to each appeal, I will probably read abbreviated version of the decision. I'll probably read the case caption to make sure we're on the right case and that we know what we're looking at, and then probably just switch down to the ultimate outcome, the order of that decision. That said, I think that's all I have for my regular introductions. Anything I'm gonna, before we launch into any cases, I'm gonna just switch to Mr. Lee. Anything we need? Anything I missed this morning?
So, Mr. Pope, I think you covered everything.
Mr. Knox, any preliminary things we need to go over before we get started?
Yes, sir, Mr. Pope. You were talking about the different options available to the board or the commission here today. And one, I just have to ask, you said remand it back to the administrative judge. What, these have been here for, what happens if the judge, in that case, if the judge is no longer employed with the staff?
Great question. I think all of the decisions, I'll double check, but I believe all of the judges who were for these decisions are no longer with the Administrative Procedures Division. So if it were to be remanded, it would be assigned to a new judge. Okay. The judge would have access to that entire case file record. They would also have access to the hearing recordings, and they essentially would pick up right where the previous judge left off. And so if you remand it with instructions, like I said, find the exact square footage, then the new judge would take the entire record, see if they can find the answer from the record, and if not, then maybe have an evidentiary hearing, but would otherwise be a new judge with the same discretion as the old judge, just a different person. Good question, though, Mr. Knox. That is I totally skipped that point, and thank you for correcting me on that.
Okay.
Yeah, essentially it'd be a new judge, and then it would import into their regular case system.
Okay. Thank you for the clarification, Mr. Pope.
There was something else I was going to try to make sure we covered real quick, but I think it'll make sense as we get into things. Oh, that's right. So we're hearing, I will just kind of maybe preliminary point out that some of the arguments you may hear are the same, and Mr. Knox and Mr. Lee. We're going to go, the commission has to make a decision on each, case essentially before us today. However, in the spirit of transparency, I will freely admit that some of these cases probably will have similar or identical arguments. Instead of having to, read the same script every single time, I will say, usually what I tell people is if they want, you can incorporate your arguments by reference and say, similar as I said in our last case, those same arguments, and it makes the record a little bit wonkier because we'll have multiple cases today, but the audio recording will cover for everything. And so for expedience sake, I can understand when people will reference, instead of having to say the exact same thing again, they incorporate their arguments by reference. And so I will just kind of say that we're still going to have, deliberations at the end of each presentation. And so you will make a distinct decision on each case. I just want to, and there's just sort of acknowledging maybe the awkwardness of the call and of the conference and of the hearings today, that they are referencing similar legal principles and things of that nature, and that we may refer to different things. We will still hear from the parties on any specific arguments tailored to each individual opinion, but we for transparency's sake, I will say that they will cover similar subject matter, is my understanding.
Mr. Pope, one inquiry.
Yeah.
We now have 8 tax years, 8 tax years in 4 counties. A lot of these decisions are, as you alluded to earlier, well, the same initial decision. Are we going to cover each individual tax year or each individual property?
Both. We'll cover. So let me go through that list of what we have remaining, and maybe this will kind of make sense. So I have remaining as the entirety of the Jeffrey Meadows case. And so we'll go over that entire initial decision order, which will cover multiple tax years. Or wait, let me make sure I got that right for Jeffrey Meadows. Correct. Jeffrey Meadows is tax year 17 and 18, 2 case numbers. So it'll be for both multiple years. That one property is my understanding, and that one initial decision order on that case. Contrast this with Stone Ridge Estates, where one of the tax years is disposed of, that 2020 tax year, but it's still one initial decision in order. So we'll still go through, they're still reviewing that entire initial decision in order, but tax year 2020 will spin off and otherwise become final. And so their decision today will be limited in effect to those tax years 17 through 19. Yeah, we'll kind of address that. I think we'll reaffirm that as we get to each decision. Just preliminarily too, I read the standard of review. Largely speaking, the commission, and for everyone in the room, the commission will not be finding a new taxable value today. That is not one of the possible outcomes of today's decision. The commission will not be finding a new value for the property, for the subject tax years. Again, the options are they can affirm that decision, the decision of the administrative judge who found that taxable value, or they can remand it back to the administrative judge or reverse it if they think part of that decision was incorrect. The commission today, as an independent body, you are not finding a new value. Your job is to review the logic and the understanding and the decision and the analysis of the administrative judge and determine if that judge, based upon what was presented to them at the time, made a correct decision. If you think they did not, you're not finding a new value, you're remanding it back. And so I just want to make that abundantly clear for everyone today. If we start getting into some relevant territory, I probably will interject on those points. Both for Mr. Knox and Mr. Lee, if you want to reference any parts of the administrative record, you are welcome to do so. I do my best to help facilitate and can pull up pages and share it on my screen so that we are all following along at the same page at the same time. That said, I will rather insist that you follow that red page number and a copy of that final administrative record that was sent out. It helps everyone know exactly what page we're on and kind of follow along. The administrative record for these cases are individually itemized based upon the individual items. And so I will insist that if you're going to reference or read from parts of the record, you very clearly identify what part of the record you are referencing. With that said, we'll go into our first case, which for no other reason than alphabetically, I have as, I believe, Jeffrey Meadows versus Henderson County. So let me pull that up and I will read our case caption just to make sure we're all reviewing the same thing at the same time. I'm going to go to that itemized version of the administrative record to find the initial decision in order, dated February 20th, 2020, I believe. The administrative judge in this case was Brooke Thompson. Brooke Thompson is no longer with the Administrative Procedures Division. And so if this case were to be remanded, it would be an entirely new judge. So the decision for this case is approximately 11 pages. The first page beginning with, in regard to Meadows Jeffrey, that's property ID 081E, Group C, Parcel 14, in Henderson County for tax years 2016, 2017, and 2018. The 2016 case number is 107643. The 2017 is 112382. And the 2018 is 119495. So for transparency, so we're all make sure we're understanding, this initial decision order covered that one property ID for those 3 tax years in Henderson County. This is the initial decision that is up for review. It begins with statement of the case and reiterates the local board values for those 3 tax years. Ordinarily, I read through the entire document, but for timing, I will dispense with that today to conclude with the conclusion on page 9. I'm just going to read that final page. Finally, the appellant spent considerable time cross-examining Mr. Hoke concerning the tax credit discount rate he applied. Mr. Hoke explained that there is a market for these credits, which typically produce lower rates than that for 10-year T-bills, but higher than 1- and 3-year T-bills. He testified that the 5% he utilized is conservative and higher than the sales he has seen in Tennessee. Respectfully, Mr. Hoke's income approach is credible, well supported, and conforms the standards of the state board. This includes his methodology for income, expenses, cap rate, and effective tax rate, and the amount of the applicable tax credits to be applied. Finally, his inclusion of the interest from TCAP funds follows the pattern set forth by the Assessment Appeals Commission and the rules promulgated by the state board. For these reasons, the appellant did not meet the burden of proof to reduce the value of the property. The assessor, however, did meet the burden of proof to merit an increase. It is therefore ordered that the appeal and counterclaim for tax year 2016 be dismissed for lack of jurisdiction. It is further ordered that the following equalized values be adopted for tax years 2017 and 2018. And so then you can see those values on that page 9. So like I said previously, this case caption included several tax years. That 2016 year was dismissed. The 2017 and 2018 had new values decided by the administrative judge. With that said, we'll otherwise enter oral argument. Again, we'll start with Mr. Knox as the, oh, sorry.
And on this page 9, values do not values and the calculations be made on I don't know what it's a typo might be, but look at what calculated $80,100.
Can you just talk in the microphone a little bit more? I apologize.
The numbers.
You need to adjust it. Yeah, we can get comfortable.
Is this better?
Much
Oh,
better. Thank you, sir.
Okay. Okay. The final value numbers on page 9 don't correspond to the numbers that Mr. Hawk calculated that the order says that they accepted those orders. And I don't know whether it's a typo or what, but before we get to talking about the numbers, they don't correspond for either year.
Okay. So there's 2 ways we can address that as well today. That sounds like a very fair question for our parties to address what that record discrepancy is from, or otherwise identify if the judge pulled from a portion of the record we're not seeing. Ultimately, as the commission, if you find that that judge made that decision and is unsupported by the record, you can remand it back to the administrative judge to explain why that final value didn't match what was in the record. I'm sure you'll hear arguments from the parties explaining kind of what happened or what that was. So I'd otherwise direct the record sort of questions to our parties. Good I would say otherwise great observation. I myself did not see that. So we'll direct that question to our parties here in a moment.
Okay, thank you.
All right, Mr. Knox, we'll start with you as the representative for the appellant, and then we'll, like I said, we'll hand it back to Mr. Lee, and then we'll hand it back to you for a brief response.
Okay.
If you others want to, sorry, I guess I forgot to formally introduce yourself to their commission so they know who they're talking to, and then feel free to proceed. Usually I try to facilitate and say, if you want to, if you could tell us specifically what you were asking the commission today to do. Is it to affirm the decision, reverse it and remand, reverse in part? And what part of the decision are you seeking to be reversed? Usually helps sort of
Okay.
focus these discussions.
Okay. But first, can I make a statement? And that will basically apply to all everything that we're going to be discussing here.
Sure, yeah.
Don't mind. I would like to just set it up, and just that way it may make it easier for you to follow my logic and where we're going with this, okay? All right. Number one, I started working in Tennessee in 2016. Never worked in Tennessee before as an agent, okay? I represented a owner out of Alabama for several years before that, in all their other properties. And then I started working on these properties after I left the company, the national company that I had been with. They came to me and asked me to handle all of their stuff. And they asked me about these, and I said, sure. And I said, we had a lengthy discussion and had several discussions about this, and that all other states that I had worked, they did not include the tax credits. So this was a question that I had with them, and there's many discussions, and they said, well, we don't feel that the tax credit should be included. I said, okay, well, then we will proceed with that as such. Well, we did, and you will find that that is the basis for everything that we're hearing here today. Now, I did go through, and all those that I withdrew, I went, and I apologize for being late to the table with that, but I had to just rerun the analysis and make sure that the values were good based off of the decisions that were made. So that was the reason for the late withdrawals, not to waste y'all's time. And I apologize that it took that much time. But anyway, in 2021 or 2022, there were some properties that were advancing to the next level of Chancery Court that y'all had ruled on, or the Assessment Appeals Commission had ruled on. And so when I asked them if they wanted to continue with them to Chancery Court, they said, we just do not have the money. We cannot spend any more time on these. So,
Mr. Knox, part of your statement is starting to sound like testimony and having to do with things that are not part of the decision. Okay.
This is just an understanding of why we're here. That's all. Okay. So therefore, after that, I started including the tax credits. Okay. So that is the number. That's one of the reasons that we're here today. I incorrectly followed the instructions of the client, and, they were contradictory to the state rules, and I apologize for that. Now, the ones that we are discussing here today, they all have counterclaims on them. And the counterclaims came after some information was submitted to the opposing counsel, and they ran the calculations, and the counterclaims for this property here, the original county value, and you'll see that on page 1 of the counterclaim, notice of counterclaim for Meadows Jeffrey, that it included 3 years, the 2016, which there was no jurisdiction, and 2017 and 18. 2017, the value was $3,483,400, and the original county value was $3,586,000, and for 2018, the counterclaim value was $3,123,300 when the county value was $3,586,000. Well, when we get to the hearing, they present DPA value for 2017 of $4,480,100, and for 2018, $3,788,600. And you've already, Mr. Osborne, you've already noticed the variations there between the initial decision order and what the DPA value was. So that's really not what, I won't get into that, but I was shocked when I saw that. I was already in front of the ALJ, and so there was no opportunity to withdraw these. I was trapped. So therefore, I had to do the best that I could with this. So that's really why I'm here, is about the counterclaims. And the taxes that were issued on this were $100,121. That's what they've already paid. With the DPA values, the increases, they're asking the taxpayer to pay another $15,310, which this is a struggling property, very much a struggling property. This one in Marshall Gardens are very, very, very much struggling. They're all run tough times, but these two especially. And with the initial decision order, it was they're asking the taxpayer to pay another $16,233. And I'm going to read something here that I hope no one's offended here, but in the book of Luke, chapter 3.
Objection, Your Honor.
Yeah, Mr. Knox, we're not doing that today. We're here to hear arguments about why you believe that initial decision order was decided correctly or incorrectly. The record has been filed and sealed. No, we're not doing that. We're here to hear arguments about why you believe the initial decision order was decided correctly and incorrectly. I can read through the entire initial decision order for Jeffrey Meadows versus Henderson County. If you would like me to read that, I'm happy to read it in its entirely. I'm otherwise going to insist. Did he just disconnect? I'm gonna see if we can get Mr. Knox back on the line. If we are not able to, we'll go from there. Mr. Knox rejoining. All right, Mr. Knox, I think you're back in the room. I don't know what happened there. Glad I got you back.
I don't know what happened either. But anyway, John responded, don't collect any more than you are.
Mr. Knox, I will mute your line if you do not follow the instruction to continue with today's proceedings.
So therefore, I have said everything I wanted to say, because this applies to everything, single thing that we are here. All of the ones that I withdrew, the values are good, but these are, they were not requiring the taxpayer to pay any more money. These are ones that they are seeking additional monies from the taxpayer, which they have already paid, and they've already fulfilled their obligation. They're being asked to fulfill additional obligations.
Okay. Any questions from our commission members of Mr. Knox? Hearing none, we'll enter rebuttal from Mr. Lee.
Thank you, Mr. Pope. My name's Robert Lee. I represent all of the assessors on the docket today: Henderson County, Gibson County, White County, and Hardin County. And today, the one before you now, it's Jeffrey Meadows in Henderson County, Tennessee. The initial appeal was filed on behalf of the taxpayer, Mr. Knox. Upon review of the property, it was discovered the tax credits had not been considered in the valuation of the property. It was strictly on the mass appraisal impact system, or CAS system at the time. Upon discovery, we found that this property had low-income housing tax credits on the property. That's in the record. And so to do that, we had to file a counterclaim to protect the interests of the county to value this property correctly. And so then we filed that counterclaim under the authority of the State Board of Equalization rules. At the time, It's Tennessee Rules and Regulations 0600-01-.10. At the time, that rule has changed, but at the time, the rule read, number one, counterclaims in a contested case must be filed no later than 30 days prior to the date of scheduled hearing, period. This rule does not preclude any party at the hearing of the appeal from propounding a higher or lower value for the property in question that the determination that determined by the county board. So under that rule, we filed counterclaims to protect the interests of the counties, to make sure that we had the correct market value of the properties. During the hearing, evidence was presented. The findings of the administrative judge clearly opposed the decisions and the methodology by Mr. George Hoke. Mr. Knox failed and refused to consider the tax credits, and so therefore no weight was given to his evidence. So we ask that the decision be affirmed. I understand Mr. Russ' question. I've been trying to find the documents and where the actual numbers came from. At this short notice, I'm unable to, but it does show and support a value. The judge, it may have been something in the hearing, Mr. Russ. I'm not sure. If there was some evidence the judge took down, maybe changed something without listening to the transcript, it's almost impossible to know.
Okay.
Okay, any other questions from our commission members? I'm briefly trying to look through the record myself to see. Any questions from our commission members of Mr. Lee? And if you have any follow-up on your previous question about next steps, that's fine as well.
I had some questions, and this would involve, I guess, Mr. Hawk, if he wants to answer them, but.
Nope, that's not.
Okay, but I'm not sure that the calculation for the tax credits from the TCAP is correct. There's some other reasons in here. I don't know. There's no real explanation of how they calculate the amount of what it's going to be, the 1 million, whatever it is, but it starts. Let me look at this and I can explain this a little better. Okay, there's a $1,281,275 available from TCAP, and it began in 2012, and it says there are 24 years remaining. But if you do the calculations there, it's only for the first year, and so it shows that the interest might not have changed from 1 year to what's remaining. And so I'm not sure whether that's the way that I know when the commission heard all of those 515 things in 2019, most of those were a 515 calculation. And one of the decisions that the commission made was to bring everything up to market at that time. So whether the amount that's owed on that is reduced or it's fixed is not explained, and it's kind of vague. And even if it is not reduced, and I'm talking about the 1 million, the interest would be reduced because it's a year less. The other question I had, the tax credit for the Section 42 portion is 5% as the discount rate for the first year in 2017, and then changes to 10% in the next year. And there's no real explanation for that. And so I guess what I'm saying, and maybe this should be in deliberation, there's several things here just with the calculations And what's been presented by the DPA, they should have to take another look at it. It just the arithmetic corrections, all of that is correct from what they've done, but whether it's followed what they're supposed to or not, I don't know. I don't know if that first year of the TCAP amount of $51,000, if that's fixed for every year or what. It's some of that's just unclear, I think. And I'm not saying that it shouldn't be there. I'm just questioning whether the methodology has been correct.
I may address that.
Yeah, I think it was.
The TCAP funds are interest-free loans. And so those loans are burned off over a period of time. So the amount of interest is the same, constant throughout the time, based on the period. And they just consider that interest subsidy is included in the NOI as an income. And so it's subsidized income that they're not subject to. So that's how the TCAP funds are. And we have decisions from the administrative judge, and I can't remember if a TCAP funding has been before the commission or not, to be honest with you, Mr. Russ. But that is how the procedure has been set forth for the TCAP funds. It is an interest-free loan. It's similar to the 515, but the 515, as you know, has a interest subsidy, as you said, 1% interest up to market rent, or up to market rates. This is basically an interest-free loan. So you look at a comparable interest rate, and then it's carried forward throughout the loan.
Okay, so it would be fixed then.
Yes, sir.
Okay, all right.
Yes, sir. As far as the discount rate, without the transcript, it's hard to know what the testimony was. There was full testimony from Mr. Hoke before the judge. And we feel like the administrative judge made his findings based on the evidence presented to him that day. So therefore, the findings should be upheld, and the commission should not reweigh the evidence. Now, if there's mathematical errors or something, that may be something that could be remanded. But we feel like the weighing of the evidence, Mr. Hoke was the only one that provided testimony about the tax credits and the subsidies. And the administrative judge found that his evidence was vital and correct.
So sorry, Mr. Russ. And was your original question just where were those numbers in the record, or was the
numbers in the record? If you go through the presentation that the DPA made, and it goes through each year, it does show the valuation and the calculation on each one. And the conclusions for 2017 and 2018 and the calculations don't match the numbers on page 9.
Oh, do they? So I'm gonna pull a couple things from the record just to make sure I understand, because the
okay.
So let me how do I get here? The initial decision order had those pages, and then I have as Jeffrey Meadows Exhibit 4 as part of the administrative record that October 16 through 17, 2019 it's like a 3-page document that was original, and I'll pull it up from the final admin record real quick. I just said, because I noticed it has those same numbers. It was part of the assessor's presentation of the ALJ, and their final value number matches that's on page 9. And so I wasn't sure if that was just an omission so I'll highlight it. I'll share my screen in a moment so we all be on the same page. Just give me a moment to pull all that up. Or if it's a record issue and I was just highlighting part of the record, I'm happy to do that real quick. Everyone just give me just one extra moment. All right, we're in Jeffrey Meadows administrative record. I'm going to pull up the notice of administrative record, which has the page numbers on it. So this is going to be beginning on page number 0180 of that final red page numbered record. I'm going to navigate to it, and then I'm going to share my screen so we can all look at the same thing at the same time, if I can get the technology to work. All right, here we go. Oh, I have to change a setting on the screen. So this was the assessor's 2016, I think, final valuation sheet. I don't know what the exact word is. And then the 2017 has that real property value of that 4,415,700. I do believe that's the same number as on the page 9. Is that
Okay, then I'm my mistake, and I must pull this from the public portal.
Oh, okay. Yeah.
It's the same calculations, but a different number down there.
So this was for, Jeffrey Meadows. That's the parcel ID, the 2016 value, and then this is the on top left corner. So the administrative record has this value in it as decided from the administrative judge.
Okay. 2017 or
this is 2017's.
Okay.
Sorry, I can't get it all to highlight on a screen, everything else. If you want to stand up and I can scroll through that as well. Or I wanted to make sure to pull this up, see if you had any questions about this calculation as well.
The earlier one has been corrected or whatever from the administrative record or whatever, but this one with the same thing is a different number. So that's my mistake. But
and the 2018 has that 3,919,100 on it for that real. This is page 182 and 181. And then in the notice of administrative record, this is noticed as assessor's exhibit part 2, I think is what it is.
Okay. Thank you.
And I may point out, Mr. Pope, the discount rate on both of those are 5. They're the same discount rates.
All right. With that said, any other questions from our commission members or anything I can pull up from the record? Okay. Then Mr. Knox, I'm going to stop sharing my screen. Same thing though, Mr. Knox, if you have anything you want me to highlight from the record, happy to highlight it to make sure we're all following along. But I'll otherwise hand it off to you, Mr. Knox, for any final comments on Jeffrey Meadows.
Am I muted? Can you hear me?
We can hear you.
Okay. All right. Mr. Russ brought up a question about methodology, and I've always had a question about the methodology applied to this property, and that the allocated tax credits were $5 million. The reason for the need for TCAP funds was because they could not sell these in the open market to raise enough capital to cover the project. So that's when the Obama administration instituted the 1602 funds and the TCAP funds to help low-income housing finish these projects to be able to provide housing for the low-income families. So out of the $5 million allocation amount, and the DPA and the opposing counsel has this information, the tax credit sale proceeds were $2,999,700. Okay, that's 59.99% of the allocated amount. So the tax credit sale proceeds $2,999,700. The 1602 funding is $1,261,275, and that provides a total capital project. In other words, money's into the bricks and the sticks, as I like to say there, $4,260,975. That's the total project capital. That's 85.2195% of the allocated amount. Okay. However, in the DPA calculations and methodology, they're using the tax credit allocation amount, the total amount. And plus they're using the full amount of the TCAP funding of the $1,261,275. So they are utilizing $6,261,275 as recognition of what's gone into the project. Well, that's $2 million less. That's 147% more than what actually went into the project. So talk about a methodology. I'm just like, this one is a head scratcher. And I have brought this up. I have communicated this over and over to no avail. So, you know, it's one thing to include the tax credits, but if you don't get the full funding amount, and granted, even if they sold these at 92%, and they only got, say, $4.5 million for it, and you wouldn't have needed the TCAP funding. So therefore, I'm fine with you.
Mr. Knox, hey, sorry, I don't want to interrupt. We're having a little communication issue. I just want to make sure we can fully hear you. Sorry, I just wanted to make sure we can get you. You're feeling a little warbled. I think maybe we just needed to load for a minute. Are you still there?
Yes, I'm still here. What was the last thing you heard?
Yeah, we're still getting some weird warbling. Let me see if I can figure that out. All right, you want to try one more time?
Yes. We're going to need to pick back up, Mr. Pope.
We're sorry, we're still getting a little bit of weird feedback for real quick. Let me see if there's a setting. I'm not sure. I don't think it's on our end as well. I don't know, something about the telephonic part of it. Are we going to back up a little bit more, Mr. Knox, and get back into it? Maybe it's working now.
Can you hear me okay now?
I think so. Maybe just make sure you talk a little bit slow. Make sure we can fully hear you.
A lot of numbers there, so that may have been some of the issues. Okay.
Okay.
Now, what I was saying.
No,
Here.
I'm still getting a hard time. Mr. Knox, you may need to exit and rejoin. That may be, it may just need to clear that out. I want to make sure we can fully hear you though. Let me see. Let's take just a quick 5-minute break if we could, and give Mr. Knox a chance to exit out and get back in full, so we can finish this argument. I hate to break up, Mr. Knox. I just want to make sure we can fully hear you, and we're getting a lot of warbling back on the line here. So if you wouldn't mind, just exit and rejoin. I'll stay in the room to make sure we can fully hear you when you get back in there. But for everyone else in the room, if you want to take 5 minutes, we'll start back at 10:10. All right, I think we're ready to get back on. We got everyone back in the room. We were able to hear Mr. Knox again. So Mr. Knox, we left off with you talking about the methodology.
Yes. Okay. Now, as I was saying, the methodology, Mr. Russ brought up the point about the methodology and how the TCAPs were calculated and things of that nature. And that, to me, that opens the door for the conversation about the methodology that was utilized by DPA to value this property. The tax credits allocated were $5 million. And that was the amount that DPA utilized in their calculations. The issue is that the tax credits were sold in the open market and only brought $2,999,700. And this is actually 1602 funds, not TCAP funds, but 1602 funds. And that was the reasoning for the Obama administration instituted the 1602 funding and the TCAP fund programs to supplement the tax credit sale proceeds to get the project capital to a point that the project could be completed. And the tax credit allocation amount is $5 million. They sold for $2,999,700, which is 59.994% of the allocated amount, less than 60%. So therefore, there was not enough generated to complete the project. Therefore, they had to apply for funding in the form of the 1602 funding, which they were given $1,261,275. 85% is usually right about the threshold level that you need to complete the project, that they feel it's sustainable at that point, or that you can, if you have to get additional funding, you at least have enough that it is sustainable without having a high mortgage. So therefore, that's when you add the tax credit sale proceeds and the 1602 funding, that's $4,260,975 total project capital. In other words, that's how much money went into the bricks and the sticks from funding from the federal government. Now, which I never understood this, and this is a methodology thing, that the DPA utilizes the full allocated tax credit amount of $5 million. And the funding of the $1,261,275 from additional funding is what they're capturing in their value analysis as well, which Mr. Russ pointed out. That is a total project that they are realizing of $6,261,275. So by doing so, they are taxing 147% of what the actual total project capital was. So they're taxing air. It's not, it's just, it was not there in the funding that went into the project. So that is a methodology question and concern that Mr. Russ brought up about TCAPs and the application or the calculation. I just thought that this was very appropriate to include in that conversation. I just have never gotten a clear understanding of the why. Now, I do want to point out, and this is about the counterclaim issue. Just bear with me a minute. The original taxes, the taxes paid on this project is $100,121 for those 2 years. Based off of the counterclaim values that I mentioned earlier, that tax estimate was $92,230. If you utilize that, that's a potential refund of $7,892. Yet when the DPA presented their case at the ALJ Administrative Law Judge hearing, the taxes were actually the estimate based off the DPA values are $115,431 or $15,310 additional funds that the taxpayer was potentially going to be taxed on. So therefore, I just feel like that was a shock after they had received the information to come up with the values for the counterclaim, which that's another question I've never really gotten a straight answer to or understood how that could happen. Let me rephrase that. So now, the last thing about counterclaims, I feel like they are a mechanism to deter property owners from appealing their properties. Therefore, when they run the risk of being issued counterclaims, so therefore, it is I feel like it's a punitive measure for what should be their constitutional right and due process. So therefore, I just they think they should be. Here's what I would recommend. Based off of the calculations with the using the sale proceeds or using the allocated amounts and the additional funding of the 6,261,275 as opposed to the 4,260,975, if that were recalculated and utilized, they would be owing the taxpayer some money here and a large amount of money. I will offer this, or I will just recommend that go back to the original assessor value of 3,586,000 and call it a day, which would be the cleanest thing for everyone. I don't know if that's possible within your purview and your options, but I think that makes the most. I think that is the best compromise that we could come up with at this time, commission members.
All right. Any questions from our commission members? Of anyone for anything? On rural, I guess specifically with regards to Jeffrey Meadows and the current appeal. Hearing and seeing none. That otherwise concludes our period for oral argument. We'll enter into deliberations. If you have any questions regarding your sort of legal options, we've got Mr. Crandell across from me to answer those questions. If you have any sort of procedural kind of how things work, sort of in terms of Administrative Procedures Division or the State Board, feel free to let me know. With that, I'll hand it over to Mr. Phil Rest as our presiding member today and our chair of the commission for deliberations.
Okay, we'll alternate this a bit. Mr. Osborne, do you have any comments or? And we're not going to take a vote now if you just have any.
Well, in the first place, I don't feel like we have the authority to consider ignoring a counterclaim. That's something that's been approved by a lot of the appeals and there's jurisdictions across the state, and it's not a penalty upon the taxpayer by any means. It's just a process of trying to arrive at an accurate value for that tax year. I don't think we have the authority to ignore that. So with that being said, I leave it up to the other commission members to see what your input may be, and we can proceed on with that. But as of now, my opinion is that we don't have any authority to do anything with a counterclaim.
Okay, Mr. Prophet.
Well, it's my understanding that one of the reasons for the counterclaim, according to Mr. Lee, was that the tax credits, hadn't been, properly applied, and they, redid their calculations, and that came into play, and Mr. Knox testified about why they weren't there, and then they came back with those, and so it looks to me like, I'm for holding the administrative law judges. I don't see that we have any grounds. I'm on the same page you are, Mr. Osborne.
A couple of comments. The taxpayer made no inclusion in his analysis for the tax credits, and that's been upheld by the State Court of Appeals and the state Board of Equalization rules. So to not include those in any way, we can't we can't go against that. I think the questions that I had about the calculations and that Mr. Lee did answer those about the TCAP funds. And in terms of my mistake there, I just looked at something on the public portal that was different, a little bit different from what was actually presented at the hearing and what was presented for us to look at before coming to this. So I think that we do need to affirm what the administrative law judge has done in this. So with that, if either Mr. Prophet or Mr. Osborne want to present a motion, we can proceed unless y'all have some more comments or discussion that we need to have. Deliberation. Okay.
I make a motion that we uphold the administrative law judge's decision. This order.
I second the motion.
Okay. All right. Motion's been made and seconded. So all those in favor of the motion to affirm the administrative law judge's decision in this, please say aye.
Aye.
Any opposed? Thank you.
Decision is unanimous and passes. This will otherwise affirm the decision of the administrative law judge for Jeffrey Meadows. Once again, that was the dismissal of the 2016 and then the values that's adopted on that page 9 of the initial decision order for tax years 2017 and 2018. That concludes the business with regards to Jeffrey Meadows. Like I said, at the top of the case, we will proceed one case after another. For no particular reason, moving into Marshall Gardens versus Gibson County. I'll pull that up. Just give me a moment and read that case caption to make sure we're again on the right. We're all on the same page with regards to the same matter. This case record is also itemized, as well as that final compiled administrative record. I'm going to read from the initial decision and order. That case caption it's under for review. To remind our commission members, this is also one that started today's appeal. I'll make sure we're on the right thing. So only 2 of these tax years were appealed. That's tax years 2017 and 2018. Case numbers for the 2017 is 112375. And for 2018, it's case number 119490. This is for the property ID 140G, Group C, parcel 2803, special interest 000. I say that out loud because if you go to the initial decision order, I will note that it cites tax years 2016, 2017, and 2018. 2016 was not appealed and is not before the commission today. Only tax years 2017 and 2018. The initial decision order is captioned as in regards to Marshall Gardens Limited Partnership versus Gibson County. That property ID I previously read, and we're on those 2 appeal numbers. So for tax years 16 through 18, the total value from the county board was $4,443,400 for an assessment of $1,777,360. And then all the way down towards page 8, the administrative law judge concluded Mr. Hoke's income approach is credible, well supported, and conforms to the standards of the state board. This includes his methodology for income, expenses, cap rate, and the effective tax rate, and the amount of the applicable tax credits to be applied. For these reasons, the appellant did not meet the burden of proof to reduce the value of the property. The assessor, however, did meet the burden of proof to merit an increase. ordered. It is therefore ordered that the appeal and the counterclaim for tax year 2016 be dismissed for lack of jurisdiction. It is further ordered that the following equalized values be adopted for tax years 2017 and 2018. For 2017, that was a total value of $5,876,500 for an assessment of $2,350,600. And for tax year 2018, it is $5,491,400 for an assessment of $2,196,560. Once again, that's the initial decision order. That's what we're here to review, is that decision as it was made with those final values. Once again, the commission, you're not finding new values today. You're here to hear oral arguments about why that decision was decided correctly or incorrectly. Let me pull that. With that said, I'll otherwise hand it over to our parties. Like I said at the top, for Mr. Knox and Mr. Lee, sorry, was Mr. Knox still in the room? Did we lose him?
No, I'm here.
No, you're there. Okay, you're there. Okay, sorry. If you, I mean, you're free to kind of reiterate or otherwise make sure you say, you know, everything still applies for your arguments regarding any overarching arguments. But if you have specific arguments with regards to the decision for Marshall Gardens, make sure you dive into the specifics of what happened in this case. But like I said, you know, all these cases I know involve similar themes, similar arguments. They are going to be decided separately though. So kind of feel free to be creative in how you do that. You're welcome to also just kind of make the same arguments you did last time, as you know, as if it's regarding the similar legal issues, things like that. With that said, we'll go ahead and get it kicked off. I'm just looking at our commission members. Just let us know when you're ready. Commission members. Sorry. Just you're ready. Okay. Then Mr. Knox, same thing, same question applies. If you could identify what you're asking the commission to do today, reverse, affirm, remand with instructions and what those instructions would be. But otherwise, the floor is yours to take off for arguments regarding Marshall Gardens.
Perfect. I am asking the commission to affirm the county's original value of $4,443,400 for 2017 and 2018. It is a value that was established prior to everything, that the owner did not think that the tax credit should be included. So therefore, I did not include them. And if I would have included them, I certainly would not be here today. I would not have appealed them, because it would have been a good value, and I would have just said, you just pay the taxes and move on. Now, that being the case, the original tax estimate, the taxes paid on this property for the 2 years is $159,003. The counterclaim tax amount for the 2 years is $202,495. So it's a potential increase of $43,493. However, the DPA requested numbers that were different than the original counterclaim amounts, and the initial decision order, they rubber stamped those, as Mr. Pope said earlier, and that leaves a tax amount of $203,437, or a potential tax increase of $44,435. Now, so this property since 2015 has already paid $747,875, almost at $750,000 to both Gibson County and to Milan, city of Milan. They paid Gibson taxes of $493,746, and for Milan, they paid $254,129. This is a property that is struggling. There is crime in the area that is impacting this property. And the tax credits, they have paid monies on the tax credits for all years. And you can't tell me that these tax credits were not factored into this counterclaim or these values, because the values went from 4,443,400 for both years to 5,876,500 and $5,491,400, which is roughly 1.1 million to 1.4 million more. Well, if you look at Mr. Hoke's tax credit sheet and you apply the discount rate for each year, if you sum total all of those years of the remaining tax credit value, that comes to $33,156 and $300. $33,156,300 in value that's being added for taxable purposes. Now, if we take just for 1 year snapshot of, and I'm looking at a value, an indicated value after the income, expenses, less personal property, $1,186,300. That comes to $13,049,300. So if you follow that math and that logic, it's hard to get from $4,443,400 and not being included in tax credits, which I just stated, income and expenses portion, to $5,942,000 or $5,876,500 or $5,491,400. It's it just it's hard for me to fathom the argument that the tax credits were not included when you look at those sum total numbers. It's virtually impossible. And for the 2017 and 2018, 2017, the present value of the remaining tax credits was $4,624,900, and for 2018, $4,162,200. So even if you're looking at capturing a tremendous amount of the value already, so I just, it's hard for me to. I'm just asking that the commission affirm the county's original value of $4,443,400. And that's a value that has already been out there and established. So I think it's possible to do that, because here's the thing. I've asked every county that I represent properties. I even asked Knox County. Knox County was the only one that had a different answer. How did you come up with these values? How did you determine the values on these low-income housing, those tax credit properties? I don't know. The state did it. The state did it. The state always did it. So they have long established that they do these valuations for the affordable housing. And they know that these are affordable housing properties. They have access to all the public data and information. So it's hard for me to understand and believe that you're missing the values out of the gate. So therefore, based off of that, I'm asking that you affirm the county's original assessed values.
Any questions?
And I said it before, but I think I won't even go there, because I think it was not. I didn't communicate it well, so I won't go there. But this is the biggest issue that I see right here. The request to pay an additional $44,435 in taxes when they've already paid $747,875. When is enough enough?
All right. Any questions from our commission members of Mr. Knox at this time? Or Mr. Lee? Seeing and hearing none. All right, Mr. Lee, we'll hand it off to you for response.
Thank you. Again, Robert Lee here today representing Gibson County Assessor of Property. One thing that Mr. Knox seems to harp on is the amount of taxes. The amount of taxes is not before this body. The amount of taxes is a mathematical formula based on the tax rate established by the county or the city government entity. What is before this body is a fair and impartial reappraisal would have been appraised on a mass appraisal techniques. Upon the appeal, it was discovered again that the tax credits would not adequately provided and accounted for in the valuation of this property. Therefore, the county filed the counterclaim to protect this interest and to make sure the value was in accordance with the state statutes and the rules. With the rules adopted, this is tax year 2017 and forward. The rules were adopted in 2016 after the cases that you've heard about with the Court of Appeals, the procedures for valuing the low-income housing tax credit properties or generally subsidized housing. The rules provide for the methodology. The rules will follow. You can clearly see from the judge's order on the initial decision and order on page 8, Mr. Knox conceded that he did not consider market rents, expenses, or the value of the tax credits. Additionally, despite his contention that a higher cap rate was appropriate, he introduced no evidence to support a cap rate. Contrasting this, Mr. Hoke's analysis relied on a national published surveys to support his cap rate. He testified about the apartment complexes are new, have quality ownership, are low risk, subsidizing housing fails at 1/3 the rate of conventional housing, and in the area where THDA deemed they were needed. The judge later further found Mr. Hoke's income approach is credible, well supported, and conforms to the standards of the State Board of Equalization. This includes his methodologies for income, expense, cap rates, and effective tax rates, and the amount of the applicable tax credits to be applied. For these reasons, the appellant did not meet the burden of proof to reduce the value of the property. The assessor, however, did meet the burden of proof to merit an increase. What we're looking for is the fair market value of the property as of the assessment date. Mr. Hoke's analysis can be found on page 118, 119 of the record and 121, 122 for the subsequent tax year. This does conform to that. Mr. Knox's argument about taxes and fairness, the hearing was fair. The taxes are irrelevant. They are just a mathematical equation based on the fair market value of the property. The fact that Mr. Knox is a contingency fee registered agent should be also taken into consideration.
Objection.
It's in the record.
If you want to, I don't know, it's in the record.
I'm not asking for any reductions here.
Okay, I think you're just
Does
making
not
a reference
apply.
to the record, Mr. Knox. I mean, that's at least at the time. I mean, we'll come back to you, Mr. Knox, if you're no longer taking these on commission on whatever it is. I guess you can clarify that. But Mr. Lee's just making a reference to the transcript or the hearing recording.
The position to sum the values over a period of time will be this amount is irrelevant. You do not sum values over a period of time and say, well, over this 10 period of time, we value this property at $6 million. So therefore it's wrong. It's got to be wrong in all the years. Each year stands on itself. You look at the fair market value on January 1 of the assessment year, and that's what the county provided the testimony through Mr. Hoke. We ask that the administrative judge's decision be affirmed.
Any questions from our commission members?
I have none.
I have none.
Seeing none. All right, Mr. Knox, we'll kick it back to you for your final reply.
Okay. I'll try to unpack everything. As I stated, he did not mention that the original county value was done by the DPA. DPA, when they submit or put their property record cards together, and when they send out their assessment notices, what does it say? Fair market value. It's established as the fair market value. Okay. Then when the taxpayer appeals it, and this is done by DPA employees, and when it goes to the gentleman who handles these cases on in legal proceedings, Mr. Hoke, what is that original fair market value? Is that all of a sudden it's a fairer market value? Is that what the new value is? A fairer market value? Fairer to who? And he states that I provided no evidence to support a cap rate. Oh, yes, I did. I provided market sales. So a market extracted cap rates are what I utilized originally. That was the difference between what I presented and what was presented by the DPA employee or representative, which he utilized the publication that is always the lowest cap rates of any national, regional publications. Now, it was established at previously by and accepted by a gentleman who's no longer with us, and I can't remember his name. He's escaping me, but he was based out of Nashville. Very well respected gentleman. So he said that you're looking for the fair market value. I could say that sounds like a blind man in the dark looking for a light switch when you start with one fair market value and you go to a fairer market value. And as far as a fee reduction, a contingency fee, I'm not asking for anything to be reduced, so there's a fee in place. I'm asking that it to be affirmed, the county's original value, the original fair market value that was established by assessment notices and property record cards, which are part of the record. You can access it. They are in Mr. Hoke's presentation. And so therefore, I ask the commission to affirm the original county value, fair market value of $4,443,400, because you said that I did not follow any kind of methodology with the state. I did it based off of my client's wishes. Well, when they determined they did not want to go further, it was very apparent that we needed to do that. And Mr. Hope will tell you, I just put my mouth on a fire hose, and for last year, from June through the end of the year, we went through 42 cases, tax years. Every single one of them, I included tax credits. Now, we may have had
okay, Mr. Knox, I'm going to cut you off a little bit because we're getting out of the realm of reference for this specific appeal and the decision of the judge in this appeal. I know you've been through a lot of other appeals this past year, but
the point of the matter I'm trying to make is I acknowledge the rules and I have moved forward utilizing those rules. There may be minor variations, but I have embraced the rules as they are written. So therefore, do not punish this taxpayer exponentially. I ask that you affirm the county's original fair market value established by DPA employees of $4,443,400.
Okay. Any questions from our commission members at this time? Seeing and hearing none, will otherwise enter deliberation regarding this Marshall Gardens. Again, this is for 2017 and 2018. Mr. Russ is a presiding member. I'll hand it over to you. Thank you.
I'm going to comment on a couple of things. First of all, for getting cap rates from the market, that's wonderful if you can do it. I always had trouble getting good cap rates and verifying sales. But unless they're absolutely current with everything, they are historic. The surveys that you use, whether it's PwC or Real Estate Research Corporation or some of the others, if you look at the top thing in each one of them, it says these are the investment requirements going forward for this quarter or whatever. So they are forward looking as opposed to being historical. Also, differences in cap rates in contention in something like this or other type controversies, condemnation or whatever, those are really, I won't say minor, but unless there's a huge difference, I would completely shy away from those. I think the taxpayer certainly had an opportunity to include his opinion of what the proper methodology is, rather than now saying that it ought to be what the county board has done. So based on all of that and what the DPA has done, it's clearly in my mind that the taxpayer didn't follow the correct procedures in this, and I would affirm what the administrative law judge has done. Sorry for jumping ahead on that, but
I totally agree.
Mr. Osborne.
I also agree also. It's a lot of information here to try to consider and absorb, and I think both parties did an excellent job in stating their position. But when it comes to the end of the day, each tax year stands on its own, and that's what we have to consider. 2017, 2018 is quite significant higher than 2016, and there might have been tax savings for 2016. You could look at it from that respect. So I don't see anything that we can do other than affirm the decision of the administrative law judge and move forward.
Okay. Would someone like to make a motion to that effect?
I would make a motion that we affirm the administrative law judge.
I second the motion.
Okay, motion's been made and seconded to affirm the decision of the administrative law judge in this matter. And all those in favor, please say aye.
Aye.
Aye. Any opposed? Thank you.
Already the decision is unanimous. That decision is affirmed for Marshall Gardens. Moving right along to our next case, I guess just alphabetically, is Stone Ridge Estates versus I have White County. I'll read off that case information again. I have this for parcel ID control map 49.
Mr. Pope, before you get started, may we take a quick 2-minute, 3-minute bathroom break?
Yeah,
Sorry, but I'm a diabetic.
Let's just take
I'm a diabetic.
Yeah, no, you're good. Let's call it an 8-minute break. Come back at 11 on the dot.
Okay, thank you very much.
Of course. I think we have everyone here. Is everyone ready to get back on it, Mr. Knox? Okay.
Yes, Mr. Pope.
Yeah.
now that Gary James has joined the meeting, he has taken over the whole screen and I can't see all the commission members.
Let me see if I can fix that real quick.
Please. I'm not sure why Mr. James is here, but you know, he was not involved.
It's a public meeting. Anyone's allowed to
okay.
observe from the public or anything like that. Yeah, it's not a closed hearing.
Okay.
I've highlighted the commission members that should replace us too. I think it's just whoever, you know, the last speaker, I think it tends to highlight is all it is. All right, then. I think we're ready to get back on it. I'll read through that case information again. Let me pull that up. So our next case is Stone Ridge Estates for several tax years. I have tax years for this one. The remaining is 17, 18, 19, but 2020 has been withdrawn at the start of today's hearings. So 2017 is case number 112074. 2018 is 119649. And 2018 is 125461. That 2020 that was withdrawn was for case number 131495. This is for the property ID of control map 049 parcel 2 in White County, Stone Ridge Estates Limited Partnership. The initial decision and order in this case as part of the administrative record was issued by Administrative Judge Mark Aaron on April 12th, 2021. Is captioned as in regards to Stone Ridge Estates Limited Partnership versus White County for tax years 2017 through 2020. Like I said, 2020 has been withdrawn prior to today. It starts with a statement of the case noting that the property was valued for tax years 17 through 2019 at $3,539,500 for an assessment of $1,415,800. Then proceeding throughout the case and concluding on page 4 with those final values. I'm sure the immediately preceding paragraph on page 3. Upon discovering that the assessor's valuation estimate for tax year 2020 was significantly lower than the White County Board of Equalization determination, the administrative judge reconsidered the grant of involuntary dismissal of the taxpayer's appeal for that tax year only, because the goal of the state board value appeal proceeding is to promote equalization by determining fair market value as of the assessment date whenever possible, and particularly in the light of the substantial increases approved for prior tax years during the same proceeding. The administrative judge is compelled to adopt the assessor's witness's opinion of equalized value for tax year 2020. Once again, 2020 is no longer part of the appeal proceeding today, rather than simply affirm the status quo, if only out of basic sense of fair play and respect for the due process. Sorry, I've actually one paragraph before that. Because of the assessor's counterclaims for tax years 2017 through 2018, the assessor's proof must be briefly addressed. In short, the assessor's valuation analysis for tax years 2017 through 2018 was meticulous and highly credible. Nothing presented or questioned by the taxpayer detracted from the credibility of the assessor's presentation. Footnote 6, the administrative judge finds that the assessors carried the burden of proof to justify its requested increase for tax years 2017 through 2018. And then finally, again, on page 4 has that total values, finding unique values for tax years 2017, 2018, and 2019. That being 2017 for a total value of $4,945,500 for an assessment of $1,978,200. 2018 having a unique value of $4,324,200, an assessment of $1,729,680. For 2019, a total value of $3,539,500 for an assessment of $1,415,800. That is the decision up for review. Once again, Mr. Knox is representing the appellant being Stone Ridge Estates, and Mr. Lee is here representing the White County Assessor's Office. With that said, unless there's any preliminary questions from our commission members, I'm hearing none from our commission. Mr. Knox, the floor is yours. to enter into your arguments. Again, if you want to reference arguments you previously made, feel free to do so as you get into the specifics of Stone Ridge Estates Limited Partnership versus White County.
Okay. Now, in the previous hearing, one of the points that Mr. Hope brought up was about fee reduction, that I'm on a contingency fee, paid on a contingency fee. Well, there was one property this year, or two properties this year, this passed in 2023, that I had an opportunity to, if the Board of Equalization would have only applied the sales ratio, there would have been I believe about a $32,000 reduction in, or the values would have been equated to a $32,000 reduction.
Is that
in
in this
taxes for
appeal,
taxpayers.
Mr. Knox? Is that
No,
is that in
there's-
this
there's-
appeal for
there's-
Stone Ridge?
There's a point that I'm making addressing
Okay.
Mr. Hoke's questioning my character about the contingency fee. So these two properties were,
I don't know if it's a question
Well-
of character. I think we all understand the
Well,
process for value appeal representation in Tennessee and generally
Well,
speaking across the country. I will just say if we're really here about the administrative law judge's decision. So I know that the decision is what we're here to review. I kind of read the final analysis on that.
Mr. Pope,
you
when
could-
someone questions
yeah.
your intentions, I feel like it's important that I address it. Okay. So what I was saying, I went to the board and there was, these two properties were scheduled to be heard for 2016, 17, and 18, had not been heard by an ALJ. So I said to the board, I said, if
Frankly,
you,
Mr. Knox, I'm gonna here. How about this? I'm gonna make a direction to the commission. Any question about contingency fee basis is not an impingement on anyone's credibility or their ability to represent a client before the State Board of Equalization. Oftentimes, it's very common to have taxpayer representatives appeal a property on behalf of a client on a contingency fee basis. It makes no difference with regards to their merit, the merits of the appeal. It's simply many attorneys do it. It's a common financing sort of arrangement for appeals to the State Board of Equalization. So, Mr. Knox, I'm going to say out loud again, I've made that instruction to our commission member. I feel like that should more than adequately address any sort of contingent. By no means is that a basis for impingement on your credibility or honorability as a registered agent for the State Board of Equalization. You are a registered agent for the State Board of Equalization. That's a common practice with State Board of Equalization appeals. I've made that instruction to our commission members, and so if you could, I would ask you just to move on and reorient your argument about the initial decision and order in this case. That is for Stone Ridge Estates for tax years 2017 through 2019.
okay, I'm still going to finish, Mr. Pope. And that is,
Mr. Knox, I will address you to move on from that point.
Anyway, the board, I said, I will walk away from
All right,
that.
Mr. Knox, if you don't proceed on this grounds, I will mute your line and we will hand it over to Mr. Lee for response.
Okay. All right. Well, anyway, it's important to note that the fair market value established by DPA for 2017, 18, and 19 for Stone Ridge Estates, we are on Stone Ridge, is that correct?
Correct.
Was the fair market value established by the first DPA representative was $3,539,500, the fair market value. When the counterclaim was filed, the new fairer market value was $4,945,500 for 2017. For 2018, $4,299,600. And for 2019, $3,719,300. Now, I say that in that I did not include tax credits. Okay, this is also a property that has additional funding. I believe it's TCAP funds, or it might be 1602. There's so many going on that TCAP subsidy. Okay, so this is the same, experienced the same issues as I mentioned Jeffrey Meadows did earlier. They needed the TCAP funding to supplement the sale proceed amount. And this goes back to a methodology issue that I raised with Jeffrey Meadows, that instead of utilizing the sale proceeds and the TCAP funding, they are using the allocated amount as well as the subsidy source. So therefore, they are overestimating the actual capital utilized that flowed to the property and to the bricks and the sticks. So that is an issue. As I said, if it was applied, I'm sure these values will be in line. But therefore, the fact that it's being structured that way, it results in a higher than the original county fair market value established by DPA. So, that being the case, you're looking at a $1.4 million increase in value with the counterclaim. You're looking at a $760,000 increase in value for 2018, and you're looking at $180,000, give or take a little bit, for all of the counterclaim value for 2019. So again, there's a fair market value and there is a fairer market value. Now, as I move forward into the latest, when I started including the tax credits, well, the gentleman who just joined us, Gary James, he chose to try and not apply the
So
sales
Mr. Knox,
ratio to it.
Mr. Knox, again,
What?
I'm sorry. You really have.
I'm just trying to get to the fairer market value and the true fair market value and what has been employed by DPA to keep the value and get the value as high as possible. That's what I'm trying to establish here, Mr.
Yeah,
Pope.
Mr. Knox, we're here to review the initial decision order. I'm more than
Okay.
happy to read the entire order. You're welcome to launch any attack you want on the logic as written out by Mark Aaron in that decision. You are welcome to attack whether his rationale was supported by evidence. You're welcome to attack whether that decision of the administrative judge was sound. Did he follow logic? Was his reasoning based upon, reality? We are not here to attack opposing parties necessarily on those grounds. We are definitely not here to address things outside the scope of that hearing and that were not addressed in the initial decision and order. If the administrative judge did not make it a finding of fact in that initial decision and order, it's otherwise, I would say, relatively irrelevant for purposes of these proceedings. So I will ask you to remain your comments directed on the initial decision and order under review today for Stonebridge Estates. I can read the entire initial decision and order aloud, but that is what we are here to review. So if you want to keep it under the review of the four corners of that page, please do so.
Okay, very good. I will do so. And I apologize, but I'm trying to make some points that I feel that are pertinent, but they're outside of the purview of this order and what we're here to. So I apologize to the commission.
Right.
Now, to support my statements about the methodology, you will see nothing in this initial decision order that addresses those that I voiced as far as that I communicated earlier about Jeffrey Meadows, as well as I communicated during the course of the hearing that I questioned the methodology utilized in the fact that they were using the allocated tax credits plus the subsidy amounts on top of that, instead of utilizing the actual proceeds from the federal government that went into the project. They were inflating the total subsidies portion, the tax credits and the TCAP funds or the subsidy funds, exponentially above what went into the project. Seriously. So therefore, Mr. Aaron, Judge Aaron, does not speak to that in his order. So therefore, I feel like that is a tremendous flaw that was not included in his decision. So therefore, based off of that, not including that in his analysis that was presented at the hearing, I feel like that the Assessment Appeals Commission should
Oh, wait, do we lose him?
should affirm the original county value, the original county's fair market value of $3,539,500 because of his flawed analysis and not speaking to the methodology and the variation of the between the allocated amounts and the actual proceeds that went into the project. I'm done. Thank you, Mr. Pope.
Any questions from our commission members? Seeing, hearing no questions from our commission members, I'll hand it over to Mr. Lee for response.
Thank you, Mr. Pope. Again, Robert Lee, appearing on behalf of the Broughton County Assessor of Property. Again, this was a matter where the property was subject to a reappraisal or a mass appraisal techniques during the discovery or during the appeal. It was discovered that the tax credits were not valued according to the procedures established by the State Board of Equalization or the rules or the Spring Hill case. That case, which has since been adopted, procedures in the rules of the State Board of Equalization, dictates how certain subsidized apartments are to be valued. Those were followed. The order clearly states that the assessor's valuation was meticulous and highly credible. Nothing presented or questioned by the taxpayer distracts from the credibility of the assessor's presentation. This is also one where the county moved for involuntary dismissal at the close of the taxpayer's proof due to the fact the taxpayer failed or refused to value the tax credits or to follow the procedures and rules of the State Board of Equalization. So therefore, we was left, the burden was shifted to the county to prove their case instead of, because we became the one seeking to a new value, and we've carried our burden of proof. We asked that these values be affirmed, that the administrative law judge's initial decision in order be upheld.
Any questions from our commission members?
No.
No.
All right, seeing none from our commission members. Mr. Knox, any final comments before we enter deliberations on Stone Ridge Estates?
Yes. Commission, Mr. Lee keeps talking about I did not include tax credits or subsidies. Well, it's very apparent that the DPA in their counterclaims and that what the information presented at the before Judge Aaron that he did not address in his initial decision order is that there's a difference between including tax credits and subsidies It's a matter of which one is more appropriate to utilize in the true value of a fair market value. Do you include information that was not actually realized by the property that went into the real property that we're here to discuss and is at stake here? Or do you use an arbitrary number that is allocated and the subsidies and overinflate the values? So I think that is the core issue here that was not addressed in the Jeffrey Meadows, nor in the Stone Ridge Estates that I brought up during the course of the hearings. And Judge Aaron says the value is credible. Well, it's credible if you minimize the purview and the view of evidence and not take into consideration the totality of the evidence. So therefore, I feel like this is a flawed decision, and I request that the Assessment Appeals Commission affirm the county's original fair market value of $3,539,500 due to this. I do not feel that the values are the decision is credible because it ignores that information that was presented in the course of the hearings.
Right. Any questions from our commission members?
No.
Seeing, hearing none, we'll otherwise enter deliberations. Mr. Rest, take it over with deliberations.
I don't see any real difference in our comments about this and the Jeffrey Meadows. And there is no recognition in the taxpayers' appeal or presentation in the administrative before that hearing of the tax credits, which are, whether you agree with it or not, that's clearly the ground rules that we have to play by. And so I think that the DPA has done a credible job in this, and I would simply affirm the administrative law judge's decision in this.
I agree. The first paragraph in page 3 of the order explains, that there wasn't a attempt to recognize the value enhancing effects of the subsidies in compliance with Tennessee law. Paragraph 2 is why the administrative law judge chose to use the assessors or the, Division of Property Assessments and the assessor, I guess, representation numbers. It looks to me like I fully understand his decision and I agree with it.
I don't have anything else to add. I agree with the thoughts and ideas that you already mentioned, and I don't see that there's anything at our status that we can do to make changes to the administrative law judge's decision.
Any other comments? Okay. Step outside my position. I will make a motion that we affirm the administrative law judge's decision in this.
I second the motion.
All those in favor, please say aye.
Aye.
Any opposed?
All right, the motion carries unanimously. That'll affirm the decision for Stone Ridge Estates for 17 through 19. No. All right. And 2020 was already previously withdrawn. Moving on to our last case of the day. This is going to be Villas of Savannah versus Hardin County. The notice of hearing addressed 2017, 2018. The 2017 was addressed the beginning of today's proceedings. So we only have the 2018 tax year remaining. This is for parcel 90A, Group A, parcel 31.01 in Hardin County. This is case number 119494 for that 2018 tax year. Administrative Judge Brooke Thompson issued the decision in this case. The decision is case captioned as in regard to the Villas of Savannah Limited Partnership versus Hardin County for that same property ID I read. Originally covered tax years 16, 17, and 18. Like I said, we're only here on 2018 currently. The case starts off with statement of the case, and it footnotes that this appeal is one of several that was argued by the same parties on the same day with much overlapping evidence. The Hardin County Board of Equalization had valued the subject property for tax year 2018 with a total value of $4,730,900 for an assessment of $1,892,360. The rest of the opinion proceeds through there all the way down to page 7, stating that on top of page 7, Mr. Hoke's income approach is credible, well supported, and conforms to the standards of the state board. This includes his methodology for income, expenses, cap rate, the effective tax rate, and the amount of the applicable tax credits to be applied. For these reasons, the appellant did not meet the burden of proof to reduce the value of the property. The assessor, however, did meet the burden of proof to merit an increase. Ordered is therefore ordered the following values be adopted, and specifically for 2018, the year for review currently, it's a total value of $5,695,500 and an assessment of $2,278,200, and then concludes with remedies. From there, that is what is up for review. That initial decision order, the words on those pages. With that said, we'll hand it over to Mr. Knox. Mr. Knox, same thing applies if you want to incorporate your arguments by reference or otherwise identify what you're seeking from the commission today, and the floor is yours for the Villas of Savannah versus Hardin County tax year 2018.
Okay. Now, I did withdraw the 2016 and 2017, but I would like to just point out a couple of things for 16 and 17 that leads to 18, okay?
Okay, and sorry, I want to interrupt you. That also confirms that 2019 was withdrawn as well.
Yes.
Okay,
So
sorry.
we've only got the 2018. Yes.
But yes, this is one order, so I totally understand how your comments for 16 and 17 are going to lead up to 18. So feel free to. Sorry.
Okay.
Sorry for the clarification, but go ahead.
Okay, and it's in the initial decision order, so it's not new information.
Yeah.
But
you're good.
But the 16, the original fair market value established by DPA was $5,973,200. For 2017, the original fair market value was listed at $5,973,200. And for 2018, the DPA, after their analysis, established a fair market value of $4,730,900. So just wanted to point that out. Now, when it comes to moving forward, the counterclaim established it says here, preliminary analysis indicates the current market values of approximately $5,665,500 for tax year 2016. The key term there is current market value. Market value. For 2017, $5,185,100 and $4,730,900 for tax year 2018. So that's the second attempt to establish the fair market value of 2018. Okay. Now, when the when the DPA presented their evidence for 2018, their third attempt, let me reiterate that, not the first, not the second, but the third bite at establishing the fair market value, it goes from $4,730,900, which they've established twice, not once, but twice as the fair market value, the current fair market value. All of a sudden, it now, oh, no. Now the third attempt, if at first you don't succeed, you don't try, but you try again. On the third attempt, it's $5,695,500 on the third attempt to establish the current fair market value. Gentlemen, I don't know what to say, but this speaks to everything that I have been addressing in all of the previous three cases, all years of the previous three properties, as well as now. It's punitive measures for a taxpayer who comes before and tries to seek some relief. Now, granted, you're going to hear, and I did not, you can read it, I did not include tax credits. That should not be the overriding factor in the fact that, look, the DPA has established original fair market value of $4,730,900. In the counterclaim, they affirmed that value of $4,730,900. And then when we get to in front of the ALJ, administrative law judge, when I have no opportunity to withdraw the case, it all of a sudden is inflated to $5,695,000 for 2018, an increase of $965,000, darn near $1 million. This speaks to everything that I have communicated or tried to communicate over and over, perhaps not very well at times, and I apologize and for that to the commission, but that is what I've tried to communicate all along. That if at first we don't get it, we'll keep trying until we get it and penalize the taxpayer. So my request is that this commission affirm the first and second DPA fair market value, which you see in black and white there in the counterclaim, established the value at $4,739,900. And I believe that the commission, if they are seeking to affirm the fair market value, it was established twice by DPA as $4,730,900. Don't penalize the taxpayer all of a sudden when it's too late to withdraw a case.
All right. Any questions from our commission members?
I do have a question. Did you have to submit any type of information before the hearing?
Absolutely.
All right. Did you, excuse me, sir.
I'm sorry, go ahead.
Did you receive any information from the assessor before the hearing as to what they're presenting or?
No, sir. Well, I did before the hearing. I did receive it like the day before or the day of. So I can't remember exactly when I did receive it, but I did, Your Honor, Mr. Russ.
Okay, thank you.
Now, can I expand
Any-
upon that a moment?
Hold on a second. Any other questions from our commission members?
Have none.
Great. Sure, you
But-
can go ahead.
But you asked if I received information from them. I received it shortly before, but I also submitted information to them prior to these counterclaim values being established, which you can see 2016 and 2017 are very close to what they came through with in the original or in their information presented to the at the hearing, at the DPA hearing. The original value that they asked for in the counterclaim, $5,665,500 for 2016. The total value that was established for that year was $5,730,100. And then for 2016, $5,185,100, which it wound up, it shot up to $5,517,800. But yet in 2017, it was $4,730,900, which was the original fair market value, that it was good. After you get information, you submit the counterclaim for the same fair market value as what was first established. And now at the hearing, you request something that's almost $1 million higher. So I wanted to point that out, that, the first two values were fairly close, but the third one, how could you miss it that much twice?
Okay, but that was really not my question. Did you
Oh, I'm
receive
sorry.
these claim values before the hearing before the administrative law judge?
Absolutely, long before.
All
Yes, sir.
right, sir. All right.
Yes, sir.
When-
I'm sorry.
when-
I'm sorry. I misunderstood
when-
your question, Mr. Russ.
Now, it's just a timing matter.
Yes, sir.
So you did receive these, correct?
Well in advance. Yes, sir.
Well in advance?
It was
do you
in
know-
advance. It was.
Oh.
I don't know exactly, but it was in advance of it. Much sooner than I did receive. Much sooner than I received their presentation. If that answers your question, I'm not sure.
Value that you're contesting right now or arguing about the 2018.
Yes, sir. It is the I'm asking that the commission affirm the value of $4,730,900, which is the fair market value originally established by DPA in the assessment notices, and then the fair market value established in the counterclaim by DPA after receiving information. So I'm asking that you affirm the fair market value that was established twice previous to this initial decision.
Okay, so you did receive this information on what they were going to present before the hearing. Is that correct?
Shortly before. I don't recall exactly how soon,
Okay.
but it was before. Sometimes when we heard Brownsville elderly that week, or those 2
Yes,
days.
sir, I'm familiar with all that. We
Yeah,
got
yeah.
quite a bit of information before this hearing today. So
Yes, sir.
Anything further? No.
that's all I have right now. Thank you.
Okay.
Seeing no other questions from our commission members, I think we're on a response from Mr. Lee.
Thank you, Mr. Pope. Again, Robert Lee, appearing on behalf of the Hardin County Assessor Property. To address Mr. Russ's questions, we did file our counterclaims on these. The appeals were filed. The counterclaims for tax years 16, 17, 18, and maybe during that time, we obtained additional discovery, was able to put blinders on to do more of a single property analysis of this property. So therefore, that's why the values presented at the hearing, which would have been shared prior to the hearing, may differ from the preliminary numbers pled in the counterclaim. The counterclaim is merely a protection to make sure that the taxpayer is held accountable for the fair market value of the property based on not the mass appraisal techniques used during the mass appraisal of the property, but whenever we look at it and see, it's similar to when a piece of property is appealed and the assessor goes out and looks at it, there may be buildings out there that's unknown to the county at the time, or the addition or something about that property that's different that the assessor had no knowledge about, and the value could change. The counterclaims are put in place under the rules to allow a jurisdiction to start looking more at the single property to determine maybe they have missed something. And so that's what was done with this. We filed our counterclaim. The initial decision or order speaks for itself about the credibility of Mr. Hope's income approach. They did conform to the standards of the board, and we more the burden is shifted in a counterclaim to the party seeking a new the value. We carry that burden of proof, and we ask that these values be affirmed. This value for this tax year.
I understand the difference in how it can change. That's not a problem. I just wanted to make sure that the taxpayer had access to this before just coming in and basically being blindsided.
The rules require that the counterclaim be filed at least 30 minutes prior to the hearing. And these counterclaims was filed in December of 2018. The hearing was held in October of 2019. So
I think you're asking were the materials that were put into evidence at the
the underlying materials would have been exchanged prior to the hearing also. The what we call the exhibits that was entered during the appeals. Both parties generally exchange those prior to the hearings.
Right, I understand that.
I don't think it's noted in the record when or what time those exhibits were exchanged in advance of the hearing. The judge did not mark it. I think you heard, generally speaking, I'm going to reiterate, I think Mr. Knox said he wasn't sure the exact timing of the exchange, nor Mr. Lee. I'm going to look to you. Are you aware of the exact timing of any such exchange?
There was not, to my recollection, there was not a scheduling order entered in these appeals.
Okay, does that answer? Yeah.
Thank you.
Any questions of Mr. Lee from our commission members? All right, Mr. Knox, any final comments before we enter deliberations?
Yes, Mr. Lee said that you have to submit a counterclaim 30 minutes before, but I think that was a misspeak on his part. Is 30 days prior to, and that was that one was absolutely that threshold was absolutely adhered to by Mr. Lee. Now, as far as the timing of receipt of documents, I have gone through, I'm on my third different email system, so I don't recall when those came through. I really don't. I don't remember if it was 1 month, 1 week, 1 day, or at the time of the hearing. I don't recall. I really don't.
Yeah, and we don't have any procedural irregularities being claimed here with regard to that notice requirement. So it's otherwise moot.
So nothing was established in the order, so we don't really know. So there's no paper trail there. So
yeah, any final comments?
But there is a paper trail of the fair market value is being established by DPA twice at $4,730,900. Twice, not once, but twice. And now when we roll into the hearing, it's $1 million higher. And the judge does not address that. He just rubber stamps the request by DPA of $5,695,500. I just think that to adherence of due process and fairness and equal protection, the fact that they have established a fair market value twice at $4,730,900, that this value should be affirmed. The original, not the original, but you could go by the second one, the counterclaim, $4,730,900. Either one, it's the same fair market value established by DPA. So therefore, that's what I'm asking the board or the commission to do.
Great. With that said, we'll enter deliberations. For our commission members, Mr. Rest, as our presiding member, the floor is yours.
Mr. Prophet, do you have anything?
No, I really see any change in this order either. Doesn't appear that there's anything that we have to go on to disagree with the administrative law judge. What I see, I agree with his decision, reading through this quite thoroughly.
Mr. Osborne?
I also agree. Looking over the administrative law judge's decision, the total value in question for tax year 2018 of $4,730,900, that was also addressed in the decision as a county board. What involvement the division, the property assessors might have had in it. They might have been there representing the assessor's office at the board. But that value that's being talked about is a county board final decision on it. The counterclaim that was involved is addressed by the administrative law judge. It's my opinion that I agree with the administrative law judge's decision. Needs to be.
Okay, good. You
I'm
want to go
sorry,
ahead and
I
make a
couldn't
motion?
I couldn't hear the last sentence.
Yeah, can you
of
just,
last
I don't think we could hear you in the
statement.
microphone. Could you say that motion again?
My motion is that we affirm the administrative law judge's decision as it stands.
I'll second that. So all those the motion has been made that we, and seconded that we affirm the administrative law judge's decision. All those in favor, please say aye.
Aye.
Aye. Any opposed? Thank you.
Decision's unanimous, and that will wrap up the business for Villas of Savannah tax year 2018. The decision is affirmed. With that said, I believe that addresses all the appeals that were originally noticed and docketed for today. Looking at Mr. Lee, making sure that's correct, or Mr. Knox, I think that's all we got for you. That will otherwise conclude our business for today. Thank you all for joining. I'm going to end the call, and today's proceedings are concluded. We will not be back tomorrow. Thank you all.